I'm Emily Taylor Poppe, and I'm thrilled to be doing double duty as moderator and presenter on this panel on legal advantage and vulnerability. And we're going to start today hearing from Issy Quek, who is joining us from Adelaide, South Australia, and we'll go ahead and let her get started.
Hi, my name's Issy Quek, and today I'll be sharing with you an overview of the research undertaken by myself and my colleague Elaine Marinus. So this presentation builds on work by myself and Elaine to consider integrated approaches, how they can address unmet legal and non-legal needs of people caught in vulnerability cycles. That previous work was undertaken as part of a one-year Master of Laws specialising in access to justice at the University of Adelaide in South Australia. Our research topics were informed by personal interest as well as learnings from practice at the Accessible Justice Project, a not-for-profit low bono law firm based in Adelaide. On the face of it, our project seems very different. So Elaine's dissertation highlights joined-up services as best practice to address the legal and non-legal needs of victim survivors of domestic and family violence. My research, on the other hand, aims to understand people's needs in the context of climate change-driven disasters in Australia by drawing together multiple theories of justice. Apologies, just got a bit of a watery eye. However, in our research, we had both done a number of similar things. We had explored what just outcomes look like in each context. We had identified groups of people who experience multiple and reoccurring legal problems and who are caught in cycles of vulnerability because they face barriers to accessing services and have reduced ability to respond to their legal problems independently. We had also identified the role of legal practitioners in addressing these legal needs and recognised the need for proactive intervention. Finally, we identified that to proactively address people's complex needs, which involve multiple and overlapping issues, these needs should not be siloed or addressed in fragments, but instead they should be addressed holistically. So just wanted to cover off a few of the key concepts in this presentation. So justice can mean many different things. It's often highly personal, context specific, and conflated with what a person considers in their view to be fair in the circumstances. In the context of this research specifically, achieving justice would result in strengthening a person's ability to respond to future legal problems. Legal need is defined in the 2024 review of Australia's National Legal Assistance Partnership, or NLAP review, as the requirement for legal services to resolve problems which have a legal dimension. More broadly, unmet legal need is defined in the first Australia-wide survey as legal problems that remain unresolved or are resolved unsatisfactorily, regardless of whether any action is taken and regardless of whether there is any involvement of lawyers or the justice system. Vulnerability cycles refer to the reinforcement of pre-existing vulnerabilities due to continued exposure to risk and compromised ability to respond to those risks. This reflects the recognition in the NLAP review that unmet legal need can escalate and further compound disadvantage for those already experiencing hardship. Our dissertations explore two groups of people typically caught in cycles of vulnerability: those who are vulnerable to extreme weather events or disasters, and women who experience domestic and family violence, or DFV. Lastly, integrative approaches encompass both theoretical and practical approaches which leverage established programs and theories to extend service delivery and more comprehensively understand and target particular needs. So integrated approaches facilitate the provision of holistic, coordinated legal and non-legal assistance to reduce the risk that needs go unidentified or unmet. This presentation aims to demonstrate that integrative approaches can do these things. First, disrupt cycles of vulnerability by providing coordinated assistance for multiple overlapping issues. Second, capitalise on established programs and approaches to extend service delivery, especially in the context of limited funding, workforce and resources. Third, increase opportunities to provide well-rounded and well-informed assistance through combined and shared learnings across disciplines. And fourth, increase opportunities for proactive intervention by the legal profession through legal and structural reform and advocacy. So our dissertations consider two ways vulnerability cycles can be addressed through the implementation and use of integrative approaches. So first, from a theoretical perspective in the context of climate change-driven disasters, and second, from a practical perspective in the context of domestic and family violence. So the first example is drawn from my research, which builds on and integrates three existing theories of justice: climate justice, disaster justice, and access to justice. I propose a new theoretical framework, access to disaster justice, which aims to more holistically understand what just outcomes look like in disasters and how that might be achieved. Access to disaster justice contributes to a conceptualisation of justice that understands the following about disasters: that extreme weather events like floods or fires will become disasters where exposure to that event is accompanied by a high level of vulnerability. With extreme weather events, a person or community with existing vulnerabilities will find their ability to respond to future events reduced, leading to a deepening of their disadvantage and vulnerability. And then proactive rather than reactive interventions across disciplines are needed to help build resilience and ability to cope with those disaster events. Where my dissertation looks forwards to the ways in which we can achieve just outcomes in relation to disasters, Elaine's dissertation looks back at the history of research regarding the impacts of DFV on women and the mechanisms set up to address barriers to accessing justice in that context. So over time in the DFV sector, it has become commonly understood that no singular professional or approach can constitute an adequate response. Vulnerability cycles have been an ongoing issue for women experiencing DFV, in part due to the fragmented support services without effective coordination, which leaves some needs unidentified and/or unmet. This has necessitated a practical integration of services to provide wraparound support. Studies have shown that, particularly in the DFV sector, coordinated approaches to clients' needs means that they are met more holistically and result in more enduring positive outcomes. So to illustrate, this diagram at a basic level shows the access to disaster justice theory. So I found that a strong direct relationship exists between climate justice and disaster justice. They have evolved at different times and in different contexts, but they share common and complementary features for understanding what justice looks like. In particular, both theories demand that action be taken to reduce or alleviate uneven climate and disaster burdens, particularly for those who don't have the means to adapt to climate change or recover from disasters. The importance of integrating access to justice theory is that it fills the gaps in the other two theories, offering consideration of justice as it relates to the formal legal system and exploring how to reduce barriers to that system. Access to justice theory also highlights the factors of disadvantage creating barriers to accessing the legal system are also those which result in vulnerability and disproportionate disaster impacts. This research considers the role of legal practitioners in a context where the usual barriers to accessing justice are exacerbated by disaster, leaving more legal issues unaddressed in times of particularly high need. The legal profession is well placed to deliver better outcomes reactively through things like pro bono legal assistance services in the aftermath of disaster, and also proactively through things like advocacy and law reform. This theoretical integration identifies that access to disaster justice is achieved by thinking about a person's needs in a way that is multidisciplinary. Appreciating people's experiences of vulnerability and disaster cannot be easily understood, particularly through any single theoretical or disciplinary lens. This necessitates service delivery, which is capable of appreciating these complexities. It may be that practitioners can look at the approaches which have been implemented in the DFV sector and apply these approaches in relation to climate change-driven disasters. This diagram illustrates the traditional model of service delivery, where legal services are delivered completely separate from other relevant professionals like social workers. This space in the middle, the gap, may result in inadequate or inappropriate referral pathways being pursued by a client and may result in a woman experiencing DFV, for example, only getting assistance for fragments of her issue. Then at the intersection of this diagram here, which illustrates the joined up service model, the client is more likely to have their specific needs comprehensively met in a trauma-informed manner. and have the necessary supports in place to effectively and efficiently assist with multiple issues. Helpfully, the Legal Services Commission of South Australia, or LSC, has a growing integrated services team led by Catherine Calero. One example of an integrated service delivered by the LSC is the Domestic Violence Unit, or DVU. The DVU was established in 2016 as a partnership between the Legal Services Commission and the Lyell McEwin Hospital. It has delivered legal and non-legal services through lawyers, mental health social workers and financial counsellors to women and children escaping domestic and family violence. They've provided legal education to non-legal practitioners such as nurses, doctors and social workers through its health justice partnerships. And it is region-specific, targeted at communities where DFV is most prevalent. Catherine notes that her team's focus on education, empowerment and understanding has shifted the way they provide services from a legal aid grant-based and therefore court-based model to an earlier intervention model, which is critical when addressing vulnerability cycles. Catherine has also observed that integration provides support for professionals working in those services. So lawyers don't feel the need to be social workers, and social workers have some certainty around where their clients are going to get legal assistance and guidance. While some challenges may arise due to concerns with differing ethical obligations and generally a lack of understanding of what each discipline offers, the LSE has demonstrated over many years these partnerships can be successful and are worthwhile. Following the success of the DVU, the LSE has also established programs to embed more mental health social workers in the LSE internally, and also the Safe and Well Kids program, which I won't go into detail about. So what is observable in the DVU case study is that increased practical integration and partnership over time has led to an increased theoretical integration through shared knowledge and approaches between legal and non-legal services. And ultimately, this has improved service delivery. So today, to summarise what integrated approaches to addressing vulnerability cycles look like, are targeted multidisciplinary research, which considers existing understandings of justice and the issues faced in specific contexts by specific groups, and coordination between legal and non-legal services to provide holistic support and solutions. From Elaine and I, we hope that this presentation will help perpetuate conversations about integrative approaches, noting there are many opportunities in relation to other legal areas.
And next we'll hear from Weston Lay, coming to us from Duke Law.
Fantastic. Good afternoon, everyone. My name is Weston Lay. I'm a research associate at Duke University. Today, I'll be presenting a study that is currently being conducted by Emily Rio, Ian Peacock, Chris Levinesque, and myself that looks at the interaction between race, legal representation, and the outcome to removal proceedings in the U.S. immigration court system. This study and its preliminary results are part of a larger project called Compound Disadvantage, Race, Criminal Justice, and Access to Justice in Immigration Courts, for which Emily Rio is serving as the principal investigator. This larger project is funded by the National Science Foundation and Duke Law School. I have organized this presentation in 3 sections. The first section provides background and explains our research question. The second section introduces the data that we are analyzing, and the third section shares our preliminary results and what we hope to be able to research in the future. This study is still in its early state, so we would appreciate any and all feedback, whether it's on theory, framing, data, or analysis. I want to start by giving everyone background on the study by discussing the larger Compound Disadvantage project I mentioned earlier. This larger project studies immigrants who have been placed in removal proceedings and have a history of criminal charges. This means that they have contact with the criminal justice system and are now going through the immigration enforcement system. This is a very important population to study because over the past couple of decades, the immigration enforcement system in the United States, as with many other parts of around the world, have become closely intertwined. For example, there's been a trend towards criminalizing immigration violations that were originally treated as civil violations. And also there's been a significant expansion in the number and types of criminal offenses that can trigger removal proceedings. We call our larger project compound disadvantage because we know in the context of criminal justice that there are significant racial disparities in everything from traffic stops to arrests to prosecution rates to even sentencing outcomes, and that collectively these disadvantages combine to produce a net negative effect on legal outcomes. We suspect these same disparities also appear within the immigration enforcement system and that they are similarly compounded for immigrants of color. There are two other studies in compound disadvantage that we have completed or are in the process of completing. The first is called Racial Disparities in Crime-Based Removal Proceedings, which will be published soon in Minnesota Law Review. One of the key findings from this study is that Black and Hispanic immigrants with certain kinds of criminal records that trigger removal proceedings face less favorable legal outcomes compared to other races. The second finding from that study is that non-white immigrants fare better when their judge is of the same race rather than of a different race. However, for white immigrants, they generally fare better than non-white immigrants regardless of the race of their presiding judge. The second study in compound disadvantage is a working paper called Exit Delayed, Racial / Ethnic Disparities in Time to Release from U.S. Immigration Detention. This second study focuses on racial disparities in time to temporary release for immigrants in removal proceedings who have been detained by Immigration and Customs Enforcement. We find in this study that immigrants with aggravated felonies experience nearly double the time in detention relative to immigrants without aggravated felonies. Another important finding is that legal access is a significant predictor of detention duration for specific racial groups. The current study that I'm presenting today builds on compound disadvantage by addressing three additional research questions. The first question is whether the effect of legal representation on case outcome varies by immigrants' race. The second question similarly asks whether the effect of legal representation varies by lawyer race. And our third question is whether racial concordance between immigrants and lawyers is associated with more favorable case outcomes. In this case, by racial concordance, we mean that the lawyers and immigrants share the same racial identity, just for clarification. The case outcomes that we are considering are rate of release from detention and also whether or not the immigrant was ordered removed from the United States. For this study, we collected and compiled three main sets of data. First, the proceedings data contains information on removal proceedings and their associated charges. These are court records that come from the Executive Office for Immigration Review, also known as the EOIR, which is the government agency that oversees the U.S. immigration court system. Second, the judge data contains information on judges, including their race. And finally, we prepared the lawyer data, which contains information on legal representatives appearing in immigration courts. Because attorney race information is not available through the Executive Office for Immigration Review, we actually predicted the race of lawyers using their name and work address through a tool called Who Are You? Together, these three data sets allow us to address the three research questions that I outlined earlier. And this study covers years of data ranging from 1998 to 2018. The 2018 cutoff is due to the fact that starting in 2018, we do not have reliable information on attorney characteristics. The one exception to this is rates of representation, which we were able to know up until 2023. We use OLS regression models for our analysis, and we use judge and completion year fixed effects so that we are leveraging only intra-judge and intra-year variations. Additionally, we control for a number of potential co-founder variables in our regression models, which if you look up there, you can just briefly look at. Except for the next two slides, the rest of these results come from our regression models. For our preliminary analysis, I want to begin by showing you the observed representation rate for each immigrant racial group by preceding completion year. So as we can see, for immigrants without criminal charges, Asian immigrants have the highest rate of legal representation throughout almost all years of data, followed by Black and white immigrants. And then at the very bottom, you can see that Hispanic immigrants have the lowest rate of legal representation throughout all years of data. A similar trend emerges when we look at immigrants with criminal charges, but in this case, we see that white immigrants have the highest rate of legal representation, followed by Black and Asian immigrants. But again, we see that Hispanic immigrants have the lowest rate of representation in all years of data. So these remaining slides will address the 3 research questions that I posed earlier. The first research question is whether the effect of legal representation on case outcome varies by immigrant race. This graph looks at the probability of release from detention and trying to answer that question. So if you look at the results for immigrants without criminal charges, those would be the blue dots that you see on the right there. We see that the effect of legal representation on increasing the probability of release is the greatest for Hispanic immigrants, illustrated by that dot right there, followed by white immigrants. To give a more intuitive interpretation of this, or a more precise interpretation of this, the probability of release for white immigrants is increased by approximately 30 percentage points when they are represented by an attorney. Meanwhile, the effect of representation is the smallest for Black immigrants, and these patterns generally hold consistent between different immigrant racial groups when we look at only the criminal charges. The next graph also answers the same question, but with regards to removal rates rather than release rates. We see that legal representation decreases the probability of the removal the most for white immigrants and the least for Black immigrants, regardless of whether or not there is a criminal charge. Our second research question considers the effect of attorney race rather than immigrant race on legal outcomes. And this particular graph looks at release from detention as the outcome. This graph shows the estimated average marginal effect of going from no legal representation to having a lawyer of a particular race. For example, if we focus on the top right blue dot for a second, we can see that among all immigrants in removal proceedings without criminal charges, their probability of release from detention decreases by over 35 percentage points when they went from not having a lawyer to having a white lawyer. And for immigrants with or without criminal charges, the increase in probability of release is the smallest for those who went from having a Hispanic lawyer or a Black lawyer. Besides, again, we can see that the trends are kind of parallel between immigrants with criminal charges and immigrants without criminal charges in terms of which attorneys provide the best release, or in this case, yeah, the best release outcomes. Next, we consider the same question when removal is the outcome instead of release. If you focus on the top left blue dot here, we can see that among all immigrants without criminal charges, their probability of removal decreases the most when they go from not having a lawyer to being represented by a white lawyer. And at the other end of this graph, the probability of removal is decreased the least, or tied for the least, when immigrants go from not having a lawyer to being represented by a Black lawyer. Our third and final research question asks whether racial concordance between immigrants and lawyers is associated with more favorable case outcomes, and this graph looks at release as the outcome. This graph shows that the estimated average marginal effect of going from a lawyer who is of a different race to a lawyer of the same race. So the most notable finding here is illustrated by the blue dot at the upper right side of the graph, which shows that white immigrants without criminal charges, having a white lawyer significantly increases the probability of release from detention relative to having a non-white lawyer. However, the effect of attorney-immigrant racial concordance on release appears to be relatively small or statistically insignificant for the other racial groups. We see a similar result when we look at removal from the United States as the outcome. The top blue dot on the upper left of the graph shows that white immigrants without criminal charges who go from having a non-white lawyer to having a white lawyer experience around a 3 percentage point decrease in the probability of removal. For other immigrants without criminal charges, racial concordance actually increases the probability of removal. In conclusion, there are several key takeaways from the analysis that I presented today. White immigrants generally receive the greatest return on representation for both removal and release rates. The marginal effect of white lawyers on decreasing removal rates and increasing release rates is generally higher than that of other races. Black immigrants usually see the smallest improvement with legal representation, and Black lawyers typically have the smallest effect on decreasing removal rates and increasing release rates. And finally, white immigrants without criminal charges benefit from racial concordance with white lawyers. However, the effect of racial concordance for other racial groups is more ambiguous. In the future, there are several other questions that we hope to address. Our dataset also contains information on the race of attorneys, also includes information on the race of judges and the gender of both judges and attorneys. And we plan to analyze discrepancies in release and removal outcomes along these margins as well. We also intend to investigate causal explanations for our results, because we did not posit any here today by showing you these preliminary results. I also have some supplementary slides on policy implications, the bivariate distribution of attorney and immigrant race, analysis on attorney and judge gender, and also the representation rate of different nationalities within removal proceedings. However, in absence of time, I think I will hand it off to the next presenter, maybe share those for questions if we get around to those. Thank you, everyone. Have a great day.
Next, we have Hugh McDonald from the Victoria Law Foundation.
I'll just get cracking. It's wonderful to be here and sharing this work, this conference here today, which has been some time in the making, and that's not just for those of us foolhardy or very, very brave to do a in-person, face-to-face survey during a global pandemic. No, it's been a long time coming because we've been struggling with some of these issues for a long time. We've really been seeking a stronger grasp of legal need and a deeper understanding of people's justiciable problem experience, and importantly, their behaviour. So in short, our public understanding of law survey, which I'll refer to as PULSE, clearly shows that in addition to legal matter type and demographics, which are two very strong drivers of legal problem experience and behaviour, well, legal capability, it also really matters. It affects how people behave, what they get out of the justice system, and we think that the findings provide a really important new perspective on legal need, and particularly importantly, what works to meet that need. So just a little about the PULSE. It's got its own website, has 3 volumes of main reporting. We've made the annotated questionnaire available together with a technical report, explanatory material, various papers, and importantly, the data set's also publicly available. So we're committed to open science. If anyone wants to play with, see our data, try to recreate the analyses, you're welcome to do so. So PULSE is a face-to-face probability sample of 6,008 adults in the Australian state of Victoria, and is really designed to tap into justiciable problem experience using the familiar legal needs survey technique. But we also went way further in 2 important respects. So that this survey operationalised the OECD OSF guidance on measuring legal need and developing techniques to distinguish met legal need from unmet legal need. And this approach shifts access to justice on from sort of questions around access to legal advisors, courts, tribunals, dispute and complaint resolution bodies, onto questions about access to fair resolution, which is a key component of the measure developed in the guidance material. But first, what's legal capability? Well, the survey set out to measure several measures, which I'll come to in a second. But by legal capability, I'm referring to the freedom and ability to navigate and utilise the legal frameworks which regulate social behaviour and to achieve a fair resolution on justiciable problems. The term is commonly used to refer to things like knowledge, skills, attributes, confidence, personal characteristics, emotional content that's sort of required for an individual to have an effective opportunity to make a decision about whether they want to make use of the justice system. Importantly, legal capability is a multi-dimensional concept. Knowledge, skills, attributes, resources. This is how Margaret Hagan captured it in one of our webinars. So what do we do with PULSE? Well, we set about developing, testing and using several measures to tap into different legal capability dimensions. So PULSE developed 5 measures which go towards knowledge, skills and confidence, namely general legal knowledge, legal confidence, a measure on the perceived relevance of law, practical legal literacy, and a measure of digital legal capability. We also developed measures that go to attitudes and narratives to law, including the perceived accessibility of lawyers, trust in lawyers. So out of these measures, they're each an individual measure, but we also developed some composite measures, putting together the knowledge, skill and confidence measures together with the attitudes to law measures. That gives us another 3 sets of measures. So in short, all of these measures unequally distributed across the community. While there were clear links to social disadvantage, this is not just about disadvantage. Rather, legal capability as we see it now adds another layer of inequality to justice across the community. So just to give a real quick look at a couple of the measures. This is the legal capability measure. Here you can see it's just organised into 3 strata. In short, all I'm trying to seek to communicate here is that there's an unequal legal confidence across the community, where some people are more confident than others. So we found just under about 1/4 that scored concerningly low in their legal confidence. Here's a snapshot of another measure. This is the practical legal literacy measure. Again, you can see the unequal distribution across the community. There were 6 items in this scoring rubric. Overall, we found that about 82% of the community likely to have sort of no difficulty completing practical legal tasks. But again, there was a sizable tail where we found what we would consider to be marginal or inadequate literacy skills. So this is things such as comprehending legal information, filling out forms, those sorts of tasks. Overall, across some of the measures, we have a sizable group that we would be concerned about on various measures, including the legal confidence measure, the perceived relevance of law measure, the practical legal literacy measure, the digital legal capability measure, the perceived accessibility of lawyers. We see high volumes or a concerning population in each of those measures. Putting some of that together to provide a sort of more nuanced picture of legal capability, we see some groups that are more or less skilled or confident, and some that are more or less with positive or negative attitudes to law. And so of particular concern to us are those who are both low skilled, low confident and negative attitudes to law. So the groups that we found this for that was particularly strong were older people aged 65 plus, people with a lower than a year 12 education, people experiencing financial distress and people experiencing severe mental distress. Volume 2 goes into a lot more detail than I have time for today. But getting on to volume 3 of our reporting, which is our latest reporting, it really explores the nexus between legal need and legal capability. It examines in details the relationship between people's legal capability and people's experience of and response to justiciable problems, and importantly, whether their legal needs were met or not. So when it comes to what people do, whether they took action, whether they handled things alone, used informal or independent help or had legal help, whether there were legal processes such as courts and tribunals, who tended to initiate or be responding to actions, how long problems lasted, whether people were able to get all the help they needed, whether they were satisfied with the outcomes or the progress of their matter, and ultimately whether their legal needs were met or not. Well, legal capability typically made a significant pivotal difference. Here I'm just going to do a quick snapshot of A few of the findings, of course, there's much more detail in the reporting. So capability was related to what people did when they faced legal problems. Here, those with the highest perceived relevance of law. So whether you see law as being relevant in the scenario measures that we presented to people, was related to whether people handled problems themselves or with informal help. So what we find here is those with the highest perceived relevance of law were using legal services at nearly half the rate. So where you saw law as being relevant and you may have gone and consulted that law yourself, you may not have needed to be accessing legal services. The findings give us a really strong insight into some self-help behaviours, and ultimately they show some quite good findings, that it was those with lower skill and confidence overall that used legal help at higher rates. Capability also mattered to processes, such as whether a court or tribunal was involved. Overall, polls found that 12% of problems involved a court or tribunal, and they were involved in significantly higher rates for those with the lowest skill and confidence and the most negative attitudes. I'll just skip to problem duration. So problem duration was also strongly related to capability measures. Here I've just pulled out the practical legal literacy measure. The patterning is clear. Problems of respondents with the highest practical legal literacy lasted far shorter than those who had practical legal challenges. Whether people agreed or disagreed they'd been able to get all the help they needed was also related to legal capability measures. Again, low skill and confidence was a powerful barrier to getting the assistance needed. Unsurprisingly, by this stage, capability also related to satisfaction with problem outcomes and progress. Here I've pulled out the practical legal literacy measure again. You can see how practical legal literacy is negatively associated with satisfaction. Getting to the big point, it's a similar story for legal need. So while polls found that unmet legal need is common, even where legal assistance was obtained, it was even higher for those with lower skill and confidence and more negative attitudes. This is more clearly set out in the report than I can convincingly cover. So where does this leave us? Well, the findings provide a new perspective on legal need and access to a just resolution. We found that legal capability was related to nearly everything that we were looking at. And so it points to a critical juncture between matching services with need. This points us straight towards people-centred justice. We could have just as easily been talking about it in the room next door. So lower capability meant extracting value from legal services and the justice system was less achievable by some people. Unmet need was routine, but capability related really to what people were able to do and get from law. Legal capability could take on a vicious or virtuous guise. Those with lower skill, confidence and more negative attitudes were less able to handle problems themselves. They sought help more often, but they got less adequate help for them, resulting in more unmet legal needs and worse outcomes. Attitudes appear to stem from experience and to shape future behaviour. So there's a capability appears to have a role in many of the inequalities in experience and resolution of legal problems. And so we see a capability asymmetry lying really at the heart and behind the demographic differences we also see in the work. Asymmetric skills can lead people down different paths to justice and bring about different outcomes. So just to wrap up, we think we need to be taking capability seriously, and the capability can help to better ensure that the justice system does not amplify capability, asymmetry and advantage, and it points to the need to shift to more people-centred justice approaches to better recognise and respond to diverse legal need and capability across the community. And it further underlies the really common finding, one-size-fits-all solutions don't work well for any particular group, but particularly when it comes to the capability, reviewing, designing, thinking about all interactions at all touch points of the justice system, being mindful of the diversity of the community that you would like to use services and institutions. That's me.
Awesome, thank you. So again, I'm Emily Taylor Poppe. I'm from the University of California, Irvine, and this is work that's co-authored with Meg Doherty-B, who's at the University of Wisconsin. And this comes from an article that has a slightly longer title that is forthcoming in Law and Society Review. And you'll see the first part of the presentation is a little bit law and society theory-ish. So if you're an academic, great. If you're not, hang with me to the end. So this paper is called Legal Actuation. What the heck is legal actuation? So this paper, like lots of my other work, started because I was looking for a citation for some other paper I was writing, and I couldn't find one that really fit what I wanted. And so I said, you know, maybe there's a gap here that I should point out. And that is that we spend a lot of time in this audience, for sure, thinking about justiciable problems and legal needs. And most of that work is really thinking about reactions to civil legal problems. Something has already happened that's a problem, right? And we're thinking about how do individuals respond to those problems, and that is all really important stuff. But in this paper, what we wanted to think about was, what about the proactive side of things? There's also legal need in a proactive world, which is more likely to be a transactional world, kind of an ex ante versus ex post world. And we are certainly not the first people to have ever thought about this or pointed this out, especially Gillian Hadfield in her work has kind of pointed out the huge difference between this is exactly how law works for corporations, but not for people. So we wanted to do some theoretical work, really thinking about this proactive use of law, but from an individual perspective. So in our 2x2 table here, we're differentiating legal behavior that's individual versus group-based, and whether it's reactive or proactive. And we're sort of pointing out that we think this quadrant 1 over here has sort of been under-theorized in the law and society literature, and that it merits some additional attention. So in the paper, we do an empirical case study, and the context in which we do this is estate planning. And for those who can't read the slide in the back, he says, I just need to get all my affairs in chaotic neglect before I die. Which is, of course, not what anybody thinks, but what lots of people do. And the reason that we pick estate planning as an area that's worthy of study is because it's actually really broadly accessible. And I'm going to say, yes, I really do mean that. I get a lot of pushback on that, but what about lower income people? Yes, in absolute terms, values are lower, but the need for those resources can actually be higher. And in other work, actually co-authored with Meg, we've done work showing that the laws of intestacy, the default laws, rules for how property is distributed at death, are actually less likely to serve people in non-traditional family forms. And that's also associated with wealth. So in fact, it's often could be that people with fewer assets or less income actually benefit in some ways more from some forms of estate planning. So if I haven't convinced you, talk to me after. I'll give you, I'll defend that point a little bit more. But we wanted to look at estate planning. So part of what the paper does in thinking about this theory is we're thinking about the fact that estate planning we know is structured by wealth. We just know that to be true from a body of empirical work, that people who have more wealth are more likely to have engaged in estate planning. We want to go beyond that to try to understand why. And to do that, to try to get a bigger sense of what might be driving other types of this legal actuation or this sort of ex ante proactive legal behavior. And part of what we point out in the paper is that there are sort of two pieces to this. One is the more opportunities, right? So if we assume that law is really structured to meet the needs of those with greater power, there are probably going to be more opportunities for those with more power to use law in ways that generate optimal outcomes for them. So part of this is an opportunities piece. Where are there sort of opportunities to gain an advantage? But there's also a utilization piece. When do people see and when are people able to act on these opportunities that present themselves? And there, we wanted to look at three potential mechanisms that could be underlying this kind of wealth effect that we know exists. The first one is legal knowledge. So we spend a lot of time in the access to justice world thinking about when do people identify they have a legal need, when do they have the legal knowledge that they need to be able to respond to that. And so we look at legal knowledge. The second is legal socialization. So thinking about how and when are people socialized to see law as a way to address a problem that you might experience. And in this paper, what we're doing that's sort of important in the theoretical literature is we're talking about use of law as an advantage and positive legal socialization. So sometimes, I've also done this presentation with a big picture of Trump from the New York Times special expose about the Trump family's use of extensive tax minimization techniques, right? There's socialization that happens on a positive side, which has been there's been much less attention to this sort of in the literature, which a lot of times is thinking about legal cynicism or legal enemy, thinking about ways in which people are kind of negatively socialized toward law. And then the last, it's so lovely that I'm going after Hugh, is legal capability. And the measure that we were using here is sort of a legal confidence characterization of legal capability. And so our theory was that all of these mechanisms could really be what's helping to drive the wealth effects that we see. So we wanted to test that. So that was our research question, is do any of these mechanisms help to drive this wealth effect that we see? And the data that we're using is a custom survey. It was administered by Qualtrics in 2019. That makes it a little bit old, but it has the plus side of not being during the pandemic, when I think anything about estate planning would be really biased and odd. I kind of wish I could redo it now and do a before after, but I didn't think about that because I didn't know. But that's what we're using, pretty large sample, online survey, consistent with national characteristics on many demographics, but not a probability survey. And I'm going to show you some descriptive results, and then we do a regression as well. So first was legal knowledge. And what we asked people was basically, do you know what would happen to your stuff if you died without a will? And what was interesting in the results is that the real effect is between the people who say, I don't know, and the people who pick an answer. We don't find big differences between the people who picked the correct, it was a multiple choice question, the people who correctly identified how the laws of intestacy work. They don't look any different than the people who picked wrong answers, but they look different than the people who said, I don't know. And so here, what we're looking at is here the proportion of people who have a will, a trust, a power of attorney for health, or a power of attorney for finances, and they're within wealth categories. So negative wealth, zero wealth, less than $150,000 or $150,000 more in wealth. And what we see in these descriptive results is really consistent indication of an effect here of this having the legal knowledge, being able to give an answer to this question was associated with you being more likely to have each of these instruments. Now, somebody out there is a quantity person saying, could this be reverse causality? Yeah, sure could. That's the next paper. But we do find this link, whichever direction it's going, between legal knowledge and having each of these instruments. So then we did the same thing looking at legal socialization. And here the way we measured it is we looked at, do you have a parent who has a will? Do you have a grandparent who has a will? Have you ever been involved in estate administration? And what we have here are we have people who have none of those things. We have people who have all of those things. And then we have people who have some, but not all. And that really, we played with lots of different formulations of how to measure that. That really seems to kind of best capture the variation we were seeing in the data. And what we see again is we find evidence across each of these instruments that this mechanism appears to be doing something. So even within each of these wealth groups, we're seeing that people who have more socialization, kind of more interaction with this area of law, are more likely to have engaged in this behavior themselves. And then our last was legal capability. And here we were using a scale, and it's the legal confidence scale. So it's one of the earlier, Pleasance and Ballmer developed it. And basically here, it's a measure, it's a scale of legal capability. So the graph's a little bit different. But again, here we're looking at average legal capability for people who either do or do not have each of these instruments. So again, we see descriptive result that this mechanism appears to be capturing something underlying this wealth effect. So then we move on to model. We do an OLS regression model, and we are also controlling here for wealth, race and ethnicity, gender, age, education, marital status, and parental status. And we're still getting results. And so what we're looking here are the average predicted probabilities within each of these. And again, we see the effects are stronger or weaker across the mechanisms, but we're still capturing a difference even after we're controlling for all these other things. And then last, I know because there's some quantity person out there, we also ran it within wealth to just fully interact the model. So everything's interacted with wealth. Essentially, we're running it separately by different wealth groups. And some of it starts to drop out at that point. But also keep in mind that people with negative wealth are less likely, a smaller number of them have engaged in the positive behavior. So our numbers get smaller. But again, even when we split it that finely, we're still seeing effects. So why does anybody care? If you're a law and society person and you are kind of looking for new theory building, this paper might be helpful. I keep trying to convince people that they should care about estate planning. I don't know, I'm trying to fight the good fight, we'll see. I think it's also important for this idea of exposure to law as a positive, because we spend a lot of time thinking about the reverse, but I think part of what drives the inequality is that it goes both ways. And for access to justice folks, I want to push us on that when we're thinking about how do we define access to justice, to also think about the ex ante, to think about the proactive use of law. I think it very often gets left out of how we kind of formulate what we're trying to address. But I think there's room there to also think about additional needs. And that's it. Thank you. And so now we'll take questions. Bueller? Yeah.
Thank you all for very interesting presentations. I have a question actually for Emily, for you on kind of almost that very last slide. And the question is how you think of the legal actualization overlapping with something like what we hear in sort of policy circles about preventative legal services, prevention, and also what areas you'd look to next after wills and estates.
Great. So yes, I totally think this builds on this idea of kind of preventative care. And in the paper, we try to talk a little bit about, for example, problems with insurance. You can see it in a couple of the legal needs surveys. So it's especially, it comes through on like problems with benefits or problems with insurance, where it looks like the problem dates back to kind of not understanding the policy, not understanding the application process. So I do think that sometimes when we don't deal with the with the issue on the front side, it comes back in the backside as a problem. So I definitely think that. And I think I either skipped a slide, but I have another slide that talks about where else does this happen. So I also think about employment contracts. I think about in the estate planning context more broadly, it's also guardianships and whether they get established early or they wait until there's a real problem. I think about service contracts, leases, mortgages, other loans, student loans. So I think there are a number of other contexts where this also comes up. And again, kind of just trying to put a theoretical framework that might help us start to think about how we can group those contexts together and see how they're the same or different.
All the presentations were really fascinating. Thank you so much for them. My question's for Hugh. It blew my mind a little bit, the graph on relevance of law and then using different types of help. And if I understood it and understood you correctly, saying that even folks who have a lower appreciation of the relevance of law are nevertheless high users of legal services to address those problems. But then later you said, but then they're not as satisfied with them or they don't work as well. So I sort of didn't expect to see that result because I figured low relevance, you're not going to engage sort of formal legal services. So could you say a little bit more about that, or like did that surprise you, or and what you're thinking about it?
Absolutely. And this is one of the exciting bits about this line of research. It does throw up the unexpected, and it provides a sort of a more nuanced understanding of a whole range of things. I didn't go into it here, but one of the groups that we were quite surprised at when it came to the legal confidence measure were carers and our First Nations people, because we would have kind of predicted the other way. We did predict that they would have a lower confidence, but in causing us to stop and think about it, no, it makes perfect sense. If you're in a group which has had to fight really hard for your rights and entitlements and are used to battling bureaucracy, kind of what Becky was mentioning earlier in the earlier session, that you do take on a confidence. Yeah, I can battle City Hall. I come from a community that's used to doing that. The most important and the least surprising sort of finding in legal needs research is if you don't perceive the law as being relevant to you, lo and behold, you don't try to make use of the law to deal with it. But what can happen is you come into contact with other people, with other intermediaries who then funnel you to law. What the legal capability findings suggest to us, though, is that, and I didn't go into a lot of detail in the presentation, it can be sort of virtuous or vicious. And sort of the skills, the confidence, the knowledge, that all goes to supporting and extracting higher value out of the legal assistance services that you're engaging with and benefiting from, which then accounts for, if you've got lower capability, why you are not able to, or people aren't extracting the same level of benefit and value out of services and not being able to resolve their problems themselves in the same way. So it's a much more deeper, nuanced understanding of some of the key pivot points. And, you know, I would probably go on to say that there's an opportunity for trying to move people out of the vicious cycle of capability to actually having some evidence that building and empowering can help flip the switch to provide and provide for a more virtuous relationship with the law.
Hugh, my question was for you, but I feel like you've kind of answered it. So we've got some very early emerging data that people are presenting with 2 and 3 intersectional factors are getting lots of services from us and engaging well with those services. But then we move to the 4 and 5 intersectional factors or potential legal issues with other personal attributes, and we see a drop in, we see less legal services and so a drop in engagement potentially. I think you've sort of answered what may be happening for those people who I think your language was skill confidence and negative attitude are potentially those groups. So I just wondered if you had any further reflections, but I feel like you already answered what's happening for that group and then potential things you could do for that group.
I can just give a real quick reflection. One of the things that we think we can see more clearly now is that people who are trying and failing are having a negative experience, taking negative attitudes away from law, less likely to try and engage to use it again in the future. In this last report, we've kind of begun to pick on some of the health approach to services in terms of doing no harm. The system-wide approach is responsible for this. People are having various touch points across the system and they're taking away harm because they're learning that processes or services are not responsive to them and their needs, maybe their community needs. That processes are hard to navigate, that it's not for them, it's for other people. And so this is why I'm sort of actually more delighted to be in this session than the one next door, because this is about that pivot point between the advantage and vulnerability, disadvantage.
Hello, I'm Janet Mosher and I teach here at Osgoode Hall Law School. Thank you for the panel presentations. I have several thoughts and questions. I'm going to try to kind of maybe string together. We'll see how it goes. So the findings from your research are really disturbing, but perhaps not surprising. And maybe this is jumping ahead a bit from where you are with the data analysis that you've done. But given the literature that we know around anti-Black racism and white supremacy, the outcomes, again, don't surprise me. And I'm thinking, too, about the connections in the Canadian context, and immigration isn't my area of expertise, although a little bit about it, but we have some similar developments that have happened over the last decade or so with the faster removal of criminals legislation, which, greatly expands the number of offenses for which people will be removed from Canada. We also have kind of different layered approaches depending on what your status is, whether you're a permanent resident or whether you're what we call a foreign national. And I wonder if you have something similar I'm just going to finish. We're here with the permanent resident is entitled to some kind of process that the foreign national isn't entitled to, but that process is grounded in a discretion. And again, I'm just thinking of something I read the other day where someone said, we don't need racist immigration law, we just need discretion. And it all turns on who the officials are who are interpreting it. So I wondered, If you have something similar in the American context, your study may not directly address
There's
it.
many different types of like residency statuses that you can actually have as an immigrant in the United States. One of them, as you could say, is like a permanent legal resident. And there's also different types of work visas. Unfortunately, the EOIR data that we actually have access to does not record that information on immigrants, which is unfortunate for us because I'm not really sure, as a group, we aren't really sure exactly how to penetrate that specific dimension more closely. There is a lot of information on what charges these immigrants are faced with and whether or not those charges are sustained. So I think how we'll probably try to decipher at least exactly where these disparities are emerging from. We'll try to look at comparable cases of immigrants who have similar charge backgrounds, similar sustained rates, and to see why disparities still persist in spite of that. I think that will be probably one way that we can try to actually investigate what these charges actually are.
Thank you. If I might, just for a moment, try to connect up
Sure.
part of your presentation with Issy. And Issy, just to invite you to say a little bit more about this cycle of vulnerability and how that connects up with risk. So part of what I was thinking about is the way in which particular subjects themselves are created as risky. And so Black immigrants, for example, is created as risky. And we think about the kinds of structures that create vulnerability for them. And so I'm wondering, in the work that you've been doing, when you think about this cycle of vulnerability and connection to risk, if you could say a little bit about maybe how particular kinds of structures of oppression create that vulnerability, or just a little elaboration on how you think about that cycle of vulnerability.
Yeah. In my work, which I haven't been working as a lawyer for very long, we see people with intersecting disadvantage, which really compounds the amount of risk that they're exposed to. And then in this presentation, we looked at two kind of examples of quite extreme events happening in a person's life. So women experiencing domestic and family violence, and that is an ongoing thing for a lot of women, and the cycle continues even within their interaction with the legal system and other non-legal services. And then, of course, events, extreme weather events. And I think something I might not have articulated in the presentation is that disasters aren't just the weather event itself, it's the social preconditions, it's the event, interacting with a person's disadvantage and their vulnerability. And I think the more and more we see extreme weather events become prevalent and severe, the less time people have to recover from those events. You'll also see a couple of examples recently in Australia where it's been flood, then fire, then flood, year after year. And so it makes it really hard to pull yourself out of that situation, and it just really deepens that vulnerability, and there's risk all around.
This was a great panel. Thank you all very much. Weston, just a quick question for you.
Sure.
I know in a lot of other contexts, there's been a number of advocacy groups that have narrowed their focus to the professional backgrounds of judges and the impact that can have on their adjudication. I'm just curious in your study if that's an area of further inquiry in the future, or if you found anything currently.
It's actually probably a fascinating way that we could actually try to discern some of these differences in outcomes that different groups are facing, because we are able to identify unique judges in our data. I think I mentioned earlier that we had judge fixed effects. What that's essentially saying is that we were able to identify each unique judge at the Executive Office for Immigration Review and all the decisions that they make. And so for some judges, it's a little bit hard because the number of proceedings that they actually oversee is very small. They might only work at the organization for a short time duration, but for other judges, they've been there for decades. And so, yeah, that's actually absolutely an opportunity to do more research on this project, another kind of dimension to look at.
Good, I'll be looking. Thank you.
Thank you.
I'll say that too, I really enjoyed it. I'm thinking about the connection of the estate planning and then the social services and other kinds of things, because my experience is I think a lot of people do durable power for healthcare as a result of the hospital. saying, here's a form, you know, you're coming in for major surgery, we really want you to take care of this, and sending, for me, regular, you know, updates, like, have you done this? And so, you know, thinking about how do you provide, it's a way to provide information about what could happen if, you know, by a social worker or somebody, if you don't have that, and potentially connecting that with other kinds of things. But the other thing, and Emily, I don't know if, I was thinking about the AIDS crisis, that there was tons of estate planning at that time because people realized how serious, and then there were a lot of volunteers doing it. And then the third question, and I just don't know if there's been much thought, and maybe it's because I'm old, that estate planning is also something that changes over time. And how do we, you know, you might get it together to do that, and then the person that you've designated is no longer able, or you're out of relationship or whatever, and you've got your ex-partner, you know, making decisions over things. So like, how do we think through maintaining that momentum for maintaining those kinds of documents? So any thoughts would be appreciated.
Those are all great thoughts. I would say part of the avoiding the worst case scenario of stale documents, in part, sometimes we have some good default rules that step in. So like if you get divorced, we automatically take that person out. And I think that's actually a larger point, which is in this area. Part of it is getting people more access, and part of it is also thinking about what the default rules are and making them as good as we can possibly make them. And I've talked about that in kind of other work, that the default rules should be aimed at the people least equipped to get an estate plan, in my view, which is not what they currently do. And I think your point about the AIDS crisis is great, in that there was kind of attention to this issue and that it's relevant to a particular population. I just keep I think it's broadly applicable, but I think so often it's kind of written off as like, that's only for rich people. And I think you're right that the powers of attorney for health are the one exception. And we see higher rates, and I think that's because they're accessible and they're a form and it's a standard form. I do still think there's more we could do. In California, I teach wills and trusts every year, and I always make my students go try to find the form. And for starters, the only official version of the form is in the paper books. The online version of the form is not official if you get it from an online source. And two, my law students who are second or third years, maybe this says more about my institution, but I don't think so. They find the Franchise Tax Board's tax power of attorney form, not advanced healthcare power of attorney or the default general financial power of attorney, and they don't know the difference and they don't understand the difference. So I think a lot of it is getting the word out, and how do we educate people and how do we make these accessible? I think it's a huge issue.
Yeah, I'll just say during COVID, we tried to put together a bunch of those resources and the statutory will and all those types of things. And it, but yeah, does it get picked up in Google search or anything else?
Yeah. I will say, credit to Bonnie, the California self-help things do come up very quickly in a Google search, which is excellent. Well, I think we're at time. So thank you all so much.